Welcome to Casa Academy Chapter 6, Part 3, where we will cover violations of license law, penalties, and procedures. Okay, let's dive right into this one, because honestly, it's an incredibly important topic. Understanding how the disciplinary process works really isn't just something you need to memorize to pass your licensing exam. It is absolutely foundational for your entire future career in real estate. The Division of Real Estate, or DRE, takes complaints and rule violations very, very seriously, and knowing exactly how they handle these issues is what's going to protect you and your practice down the road.
So, as your guide through all this material, we've set things up to take you step by step through the overarching 7-step journey a complaint takes through the DRE and the Florida Real Estate Commission, which we usually just call FREC. Listen, the state doesn't just hand out penalties randomly. There's actually a very strict, highly organized procedure, and it's designed specifically to ensure fairness and thoroughness. If you can really grasp the chronological flow of these 7 steps, you are going to be in fantastic shape for your exam.
All right, here's our roadmap for breaking down this pretty complex legal procedure. First, we'll cover complaints and investigations. Second, we'll look at the probable cause panel. Third, we'll navigate through complaints, stipulations, and hearings. Fourth, we'll examine final orders and appeals. And finally, we'll wrap up with a rapid-fire disciplinary process review to just really lock it all in.
Let's start right at the very beginning with Section 1, Complaints and Investigations. This is step 1 of the journey. You can think of this initial phase sort of like the opening chapter of a mystery novel. A complaint is basically just an allegation from someone claiming that a law or administrative rule has been broken. Like, for example, someone performing property management services without a license, which, by the way, is becoming increasingly common. But hey, not every single complaint triggers a full-blown investigation. Before anything else happens, we need to look at a very specific legal term, legally sufficient. A complaint analyst is going to review the allegation to see if it meets this exact definition. For a complaint to move forward to step 2, it has to allege facts that, if they turn out to be true, would actually violate Chapter 475 of the Florida Statutes or Chapter 61J2 of the Florida Administrative Code. Oh, and it absolutely must include some form of supporting evidence. If it passes that test and is deemed legally sufficient, well then the division is legally required to investigate it.
Once we cross into step 2, the investigation kicks off and a copy of the complaint is handed over to the respondent. Enter the investigator. So the really crucial thing to understand here is that the DRE investigator acts entirely like a fact-finding detective. They are out there gathering facts, interviewing witnesses, reviewing records, and they even have the power from the Division of Real Estate to issue subpoenas if they really need to track down hidden information. But, and you'll definitely want to underline this in your mind, they never, ever determine guilt. They don't offer their personal opinions, and they certainly don't recommend discipline. They just compile a report of the facts and the evidence. Literally, just the facts, please.
Okay, so once that fact-finding report is submitted, there are a few different ways things can go. For super minor violations, it might just result in a notice of non-compliance or a citation. If the person in question is completely unlicensed, the department can drop a cease and desist order on them. But what about really serious situations where the public is at immediate risk? Say someone is improperly depleting escrow funds. Well, that matter goes straight to the Secretary of the DBPR for an emergency suspension. It's also called a summary suspension, and that immediately stops the licensee from practicing right then and there to protect the public.
Moving right along to Section 2, the Probable Cause Panel. This is where we actually evaluate all those facts.
Assuming the situation didn't just end in a minor citation or a massive emergency suspension, we find ourselves at step 3. To really grasp what this panel does, think of them as serving a function that's very, very similar to a grand jury in the criminal justice system. The Probable Cause Panel is made up of 2 current or former members of the Florida Real Estate Commission. They sit down and review the investigator's file. But remember, and this is key, their purpose is not to determine if the person is guilty or innocent. They are strictly looking to see if there's enough evidence to suggest a violation might have occurred. If they say no, the case could just be dismissed, or maybe they issue a letter of guidance. But if they say yes, then we have officially found probable cause.
That brings us to Section 3, Complaints, Stipulations, and Hearings. Things are getting serious now. This is the confrontation and resolution phase.
So if the panel does find probable cause, we enter step 4, the administrative complaint. You might also hear this called a formal complaint. This is the moment where formal charges are officially brought against the licensee, who from this point forward is referred to as the respondent. Now, here's a number you absolutely must remember for your exam: 21. The respondent has exactly 21 days to respond to the administrative complaint. In that response, the licensee has to indicate whether they dispute the allegations or not. That 21-day window, it's a hard, strict deadline. Burn that number into your memory for sure.
Now, at this stage, it's worth noting the respondent doesn't necessarily have to go to a full-blown trial. They actually have the option to negotiate with the DBPR attorneys for a settlement agreement. In the real estate legal world, this is known as a stipulation. Basically, under a stipulation, the respondent agrees to accept some form of disciplinary action without formally admitting or denying the actual allegations. FREC does have to officially approve it, though. Before we move to the hearing process, your verification code is 125477. Anyway, if FREC doesn't approve the stipulation, or if the two sides just can't reach one, well then we proceed to step 5, the hearing.
At this point, the path completely splits in two, and it all depends on what the respondent said in that 21-day reply. If the respondent does not dispute the facts of the case, they go straight to an informal hearing before FREC, where the commission itself determines the discipline. And as a quick fairness side note, the two FREC members who served on the probable cause panel, they step out of the room for this part. On the flip side, if the respondent does dispute the facts, the case goes to a formal hearing. This is intense. It operates a lot like a real court proceeding. You've got attorneys, witnesses, evidence, the whole shebang. And it's held before an administrative law judge from DOA. That's the Division of Administrative Hearings.
For Step 6, the final order, you have got to remember this critical distinction. The DOH judge recommends, but FREC decides. Let me repeat that because it's a huge exam point. At the end of a formal hearing, the administrative law judge does not hand down the final punishment. Nope. Instead, they have 90 days to submit a recommended order, which includes their findings of fact, over to FREC. FREC then reviews this judge's recommendation, and they are the ones who issue the final order. They can accept the judge's recommendation, they can reject it, or they can modify it. Make sure you know who does what here.
All right, Section 4, Final Orders and Appeals. This is Step 7, Judicial Review. Just because FREC has issued a final order doesn't necessarily mean the respondent is totally out of options. Florida law ensures the right to judicial review. And here is another absolutely essential timeline number you need to know. 30. The respondent has a strict 30-day window to file an appeal, and this appeal has to be filed with the Florida District Court of Appeal. If you miss that 30-day mark by even a day, that's it. The final order stands exactly as is.
Now, while that whole appeal process is dragging on, the licensee generally cannot practice real estate. However, the court can intervene by issuing specific writs, which are basically formal legal orders. First off, if the court decides the licensee doesn't pose a threat to the public welfare, they might issue what's called a writ of supersedious. This is huge because it actually allows the licensee to continue practicing while the appeal is pending. Then, let's say the court eventually agrees with the licensee and overturns FREC's final order. In that case, they'll issue a writ of mandamandus, which legally forces FREC to fully restore the licensee's rights and privileges.
Finally, Section 5, Disciplinary Process Review. Let's recap that 7-step sequence.
We've covered a ton of ground today, right? From the very first complaint all the way up to the Court of Appeals. Let's quickly solidify the sequential memory of this journey so you can recall it effortlessly on test day. Here is your rapid-fire summary. Step 1. A complaint is received and checked for legal sufficiency. Step 2. The investigation happens. Our detective gathers facts but gives 0 opinions. Step 3. The probable cause panel acts like a grand jury to see if the case should even proceed. Step 4. The administrative complaint is filed, giving the respondent 21 days to answer. Step 5. The hearing takes place, informal if facts aren't disputed, formal before a DOA judge if they are. Step 6. FREC reviews the judge's recommendations and issues a final order. And Step 7, Judicial Review, where the licensee has 30 days to appeal to the district court.
I'll leave you with this final, highly testable question to think about. If the District Court of Appeal affirms FREC's decision, the respondent can actually seek one last review. What is the highest court involved in this entire appeal process? The answer is the Florida Supreme Court. But honestly, how often does a real estate dispute actually make it all the way to the highest court in the state? Well, that's a story for another time. Keep this 7-step sequence fresh in your mind, and you are going to navigate these questions with total confidence on your exam.